Many of our clients are very surprised to learn that when they walk in our office that they've come armed with an estate plan. After all, they're coming to visit us to talk about a will, and how can it be possible that they have their own plan as they walk in? What's interesting about estate planning is that if you die without a will, the state of Florida is kind enough to provide you with your own. It's called dying intestate, and the statutes are clear as to who will get your money and when if you have no planning in place. For most of my clients, they find that the statutes are not ideal. For example, in my situation, if I died without a will, many of my clients would be surprised to know that my wife would receive the first $60,000 of my assets, and my children would get half of what's left over, and my wife would get the other half. Most of my clients think that they should provide for their spouse first, kids second. That's not what the law does in some cases. And so having an estate plan in place to avoid that free will is a very important consideration. Now, I will tell you there are many cases where dying without a will turns out okay. I worked with an elderly client who was in a nursing home and unfortunately lost all of her money. And sadly, she even lost all of her personal effects as she inadvertently had them removed by a cleaning person. And I had to tell her in a very gentle way that she didn't need a will, because what would happen to the law of intestacy, that is, having everything pass under the state's rules, would be acceptable. And in her case, what she had left was very little, and she would die with the free will. And that meant that her kids would get whatever was in her name at the time of her death. But for most of us, that's not an ideal plan, especially if we have minor children. And the reason for that is that dying without a will and having minor children means that your money will be held in a guardianship for your kids. And when they reach that ripe old age of 18, whatever's left in their guardianship account will be distributed to them. And for many of us as parents with young children, that's a scary proposition. And so the first thing we need to think about in the estate planning process is, can we use a will, a last will and testament, as our primary estate planning vehicle? And for many clients, that's an acceptable document to dispose of our assets and also name guardians for our children. The will as a concept has been around for hundreds of years and is very clear on its face. What makes wills unfortunate is that in order to perfect our interests and our wishes, we need to go through a court process called probate. And in some cases, that's an expensive process. That can also be a time-consuming process. And I believe as an attorney and a counselor for my clients that if we can avoid the expense and delay, that we will serve our clients better. Moreover, I believe that my family should be allowed to properly mourn the loss of their loved ones, and coming to visit me to handle a probate, I believe, disrupts that process. And so for many of my clients, we will look at substitutes to a will to avoid going through probate. The biggest substitute vehicle that's used in Florida, perhaps the most common, is a revocable trust. And as we've talked about in other segments, revocable trusts are designed to take title to assets while we're living, managed by a trustee, and you can be your own trustee. And at the time of your death, the successor would step up and manage your assets without court supervision. So in many respects, we create a very seamless, smooth transition with minimal court involvement, minimal legal expense for that matter, so that our families can go about their business and make sure that they properly mourn the loss of a loved one.